Thanks for tuning in to leftcoastnews.net, news and information from the wacky, sometimes communist, liberal West Coast of the United States. For more, visit leftcoastnews.net. Well, let's review some of the legislation that passed and didn't pass in this session of Washington's legislature. House Bill 1889, on its way to Governor Inslee's desk, will remove citizenship requirements for all professional licensing applications, which proponents say will create much-needed clarity for people seeking these licenses. This means that illegal aliens can be bail bondsmen, money collectors, security guards, private investigators. That's right. Illegal aliens will have the ability to look up all your personal information as a private investigator. And a whole other slew of professional licenses. Absolutely ridiculous. Senate Bill 5804, which will require Narcan to be available in all public charter and state tribal education compact schools. This bill also on its way to Inslee's desk because, of course, we want to express to our children that it's okay to overdose and we'll give you the respawn drug to bring you back to life. Instead of addressing the drug problem, we're just pushing it along, encouraging it. Lawmakers passed a bill to curb the seizures of child support payments, House Bill 1652. In 2022, Washington took $41 million intended for parents of impoverished children under a practice allowed by federal law. They have to take their cut, but they've decided to do away with that. So if you're entitled to some child support, you're actually going to get it now. Senate Bill 6194 to outline collective bargaining rights for legislative staffers passed. Of course, a Capitol-related bill. They're all about getting that done, right? House Bill 1062, which was a bill that would stop police from lying to criminals during interrogations to get information, failed to move through the legislature. Luckily, this would have made any confessions obtained with the use of deception inadmissible in court. And I'm sorry to say, but this is a necessary practice to get these turds to confess quite often. So you can't take that away. I was a police officer for 8 years. I'm certified in several different kinds of investigations. I've been to numerous training classes for interviewing and interrogations, sex offense investigations and interrogations, drug interrogations. This is a necessary evil. But of course, these people who have never held a real job and sit in the Capitol, they don't understand this stuff. Some sexual misconduct bills passed, 1999, which is deep fakes of sexually explicit photographs using somebody's face without their permission, a real person's face. That's going to the governor's desk. House Bill 1958, which will create civil remedies for survivors of stealthing, the non-consensual removal of a sexually protective device like a condom. You'll get $5,000 and your attorney's bills will be paid for. And then you'll have the kid to deal with from whoever raped you, apparently. Here's Here's a sad one. A bill to promote inclusive education curriculum in Washington has passed both houses in a largely bipartisan vote after a rigorous debate by lawmakers. Senate Bill 5462 is going to update learning standards to include education on the LGBTQ plus community and also require school boards to adhere to a model policy in adopting inclusive curriculum, highlighting historically marginalized groups. So I talked about this bill. This is going to require all kinds of sexually explicit materials that cannot be removed from the school. I'm not quite sure how this is going to work with the Parental Bill of Rights, because that sort of counteracts exactly what they want to do with this bill. So that's going to be an interesting battle. This one I find rather interesting. House Bill 1455, which is in regards to child marriage. Currently, Washington law allows 17-year-olds to marry with parental consent, with judicial approval needed for those younger than 17. The bill would remove these loopholes, voiding all marriages in which either party is under 18. Proponents argue this bill will protect children who are often too young to access supportive and legal resources from the violence, abuse, and crime associated with child marriage. Now, I don't think kids that young should get married, but I think it's interesting that you've got Democrats, this is a Democrat-sponsored bill, saying they're too young to get married, but you're allowing 13-year-olds to have sex change operations and everything else behind their parents' backs. Where is the logic behind that? What is the difference? You're saying they're too young to get married. They're not, able to deal with that at that age. Of course, they're trying to say that this is more to do with violence and abuse, but on the other hand, you're saying that a 13-year-old has enough wherewithal, enough life experience to make a decision about changing their sex? I don't think so. The legislature passed a stripper's Bill of Rights this session. After failing to do so last year, Senate Bill 6105 establishes a number of new safety protocols for adult entertainment, including panic buttons, customer behavior rules, and worker safety training. It also includes a warning that an establishment could lose its liquor license if it violates certain laws to adult entertainers. The bill awaiting the governor's signature also gives entertainers more rights concerning their pay and employment status. I believe that bill is also going to allow alcohol at strip clubs, which Washington was apparently the only state in the U.S. that didn't allow it. Of course, we know about the 3 wins that those of us on the conservative side finally got. 3 of our 6 citizen-led initiatives proposed to the legislature were also approved to loosen police pursuit restrictions, establish a kind of parents' bill of rights, and to forbid a state income tax. Although lawmakers testified during debate that provisions protecting parents' rights are already in state statute, the initiative was approved anyway, and the legislature cannot pass an income tax. It would require a constitutional amendment, and numerous previous attempts have failed. The police pursuit measure does undo some previous legislative work to limit police chases. Thank God. That leaves the 3 tax measures for voters to decide on the November ballot. Conservative organization Let's Go Washington, funded by Redmond hedge fund manager Brian Haywood, wants voters to repeal the Climate Commitment Act, yes please, which created Washington's new cap and invest system of carbon auctions. The same group has proposed a repeal of Washington's capital gains tax, and the third initiative would weaken the state's long-term care insurance payroll tax, which is a big joke. I'm sure you're aware of the anti-gun laws that were passed. House Bill 1903, which will require gun owners to report stolen guns to law enforcement within 24 hours or face a potential fine of up to $1,000. And House Bill 2118 on gun dealers' security measures also passed, requiring gun dealers to have surveillance cameras even if they are selling weapons out of their homes, along with a slew of other regulations packed in there that is effectively going to put a lot of FFLs out of business. So, of course, there were others that I'm not going to talk about. A bunch of their housing crap didn't pass, like trying to split lots and put sixplexes and fourplexes up into small, normally residential-sized lots didn't pass, and some others that they're very disappointed about. Overall, what is the outcome of all this? Well, more of your rights have been chiseled away as usual. And as long as the Democrats have a majority in our state capital, this is going to continue to happen year after year. Your rights are going to continue to be chiseled away. This state, which is basically socialist as it is crawling towards communism, and that's the way they want it. Is that the way you want it? We've got to get these clowns out of office. There's one more bill I want to talk about that is on its way to old Jay Inslee's desk, and this is truly a 1984 bill, if I've ever heard of one. And I talked about this before, and it, of course, has passed. Substitute Senate Bill 5427, a controversial piece of legislation aimed at combating hate crimes and bias incidents in Washington. The bill, which passed through the Washington State Legislature, seeks to create a bias incident hotline under the management of Sideshow Bob, the State Attorney General's office. The stated intention is to support victims of hate crimes and track bias incidents. The Attorney General's office must oversee hate crimes and bias incidents hotline staffed during business hours dedicated to assisting people who have been targeted or affected by hate crimes and bias incidents. The hotline must provide appropriate victim-centered, culturally competent, and trauma-informed information and referral. Be as accessible to as many residents of Washington as is practical within appropriations, regardless of language proficiency. How often do you think that's going to get abused? According to the bill, bias incident means a person's hostile expression of animus toward another person, relating to the other person's actual or perceived race, whatever you believe you are, color, ethnicity, religion, ancestry, national origin, gender, sexual orientation, gender expression or identity, or mental, physical, or sensory disability. A bias incident is deemed to be non-criminal in nature and does not include expressions of support for or opposition to a government's policies or actions protected under free speech, unless, of course, you happen to mention any of the multitude of things that I just listed off. Critics of the bill, such as Representative Cindy Jacobson and Representative Jim Walsh, argue that the legislation could potentially infringe on free speech rights by policing thought and speech rather than actions. They raise concerns over the subjective nature of determining intent and the consequences of reporting someone for an alleged bias incident. Liberty Nation reported, to be clear, this isn't merely about going after people who have allegedly committed physical hate crimes. It also targets reported instances of a person's hostile expression of animus toward another person, relating to the other person's actual or perceived characteristics. Literally, the hotline gives people a way of informing on others supposedly guilty of thought crimes or perhaps speech crimes. The bill as passed does make it clear that these bias incidents do not include expressions of opposition or support for the actions or policies of a foreign or domestic government protected under free speech. So sure, one is still free to criticize an elected official, but express any opinion someone else decides is aimed at an individual because of that person's actual or perceived characteristics, and one could find oneself in the AG's crosshairs. So my comments about an illegal alien getting to have a professional license in the state of Washington, is that now a hate crime? A bias incident? It is easy to see, then, that any expression of opposition to, say, transgender ideology would get someone reported to the hotline. Free speech, at least in the 3 Washington counties to which this program will initially be rolled out, appears under threat. If one cannot say anything that another person of a different race, sex, religion, or sexual orientation finds offensive in some way without being reported to the Attorney General's office, then one no longer enjoys the constitutionally protected right to freedom of speech. Supporters of the bill argue that this isn't the U.S. Congress making a law that restricts free speech, so it can't be unconstitutional. The Washington Constitution, however, also protects free speech. Article 1, Section 5, every person may freely speak, write, and publish on all subjects, being responsible for the abuse of that right. Getting away from the sheer creepiness of people being reported to the authorities for merely expressing an opinion, Representative Cindy Jacobson succinctly pointed out the ominous flaw in the bill. I think it's difficult to put things into law which look at the intent of people rather than the actions they take. No kidding. Since when can you be liable for intent? You have to commit some kind of action to get in trouble. Representative Jim Walsh agrees, saying if a crime is a crime, if someone has been assaulted, if property has been damaged, then the proper recourse is to contact law enforcement and pursue a remedy, pursue justice in that way. The bill received strong support in the legislature, with final passage votes of 30 to 18 in the Senate and 56 to 39 in the House. The bill is now on the governor's desk. If signed, it will take effect on January 1st, 2025, with provisions for a pilot hotline program in select counties by July 21st, 2025, statewide implementation by January 1st, 2027. Well, you know the 3 counties that'll be happening in. I know that at least King and Snohomish County will be 2 of them. And then possibly Pierce County, I would assume. This doesn't say, but I'm sure we can look forward to this coming to the entire state. This is just one more way to suppress the dissenters of the groupthink mentality in this state and the entire left coast. Sick. You are not going to tell me how to think or what I can say. Period. This last story, a story of hope, comes to us from the left coast state of California. California tried to pass a law, or did pass a law, that they could only buy, Californians can only buy 1 gun a month. And it has been struck down. In his March 11th ruling, a federal judge said that the 1 gun a month law does not adhere to requirements for gun restrictions outlined by the U.S. Supreme Court in a pivotal 2022 decision. Defendants have not met their burden of producing a well-established and representative historical analog to the OGM law, U.S. District Judge William Q. Hayes wrote in his decision. The court therefore concludes that plaintiffs are entitled to summary judgment as to the constitutionality of the OGM law under the Second Amendment. The U.S. Constitution's Second Amendment states a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. The The Supreme Court's 2022 ruling in New York State Rifle and Pistol Association versus Bruin says that if a law regulates conduct covered by the Second Amendment, officials defending the law must show it is consistent with the nation's historical tradition of firearm regulation. That's the thing about these gun laws. Like, when they try to pass these laws, they have to show that this is a precedent. This has already happened in history sometime. Otherwise, there's no way to pass it. So how half of this crap passes, especially in our state of Washington, I don't know. I don't understand. But this story gives me some hope that maybe some judge that's not under Inslee's thumb or some liberal lunatic will strike down some of these ridiculous laws that are being passed in Washington right now. Defendants must provide historical precedent from before, during, and even after the founding that evinces a comparable tradition of regulation, the High Court stated. Justices instructed lower courts not to uphold every modern law that remotely resembles a historical analog, but that the analogical reasoning requires only that the government identify a well-established and representative historical analog, not a historical twin. They also issued guidance for judges to consider how and why regulations burden a law-abiding citizen's right to armed self-defense, and to examine whether modern and historical regulations impose a comparable burden on the right of armed self-defense, and whether that burden is comparably justified, are central considerations when engaging in an analogical inquiry. The law signed by California Governor Gavin Newsom in 2019 barred people who bought a handgun or semi-automatic centerfire rifle from a dealer from applying to buy another handgun or semi-automatic centerfire rifle for at least 30 days. Gun violence is an epidemic in this country, one that's been inflamed by the inaction of politicians in Washington, Mr. Newsom, a Democrat, said at the time. While Washington has refused to act on even the most basic gun safety reforms, California is once again leading the nation in passing meaningful gun safety reforms. Well, apparently you were violating our rights. Big surprise, bud. Gun owners and groups sued in 2020, saying the law violated their constitutional rights. After the 2022 Supreme Court ruling, defendants were ordered to provide historical examples of similar laws, which they tried but failed to satisfy the court. So, if California can do it, maybe somehow Washington can pull it off, get some of these ridiculous laws shown as unconstitutional and removed. Well, if you thought I was going to leave you with a happy ending, sorry to disappoint. Even though I said that I was hopeful that somehow Washington State could turn things around, get some of these things struck down, such is not the case with the lawsuits against firearm manufacturers in Washington. A federal judge in Washington State rejected a gun right group's challenge of a new regulation that opens firearm manufacturers to lawsuits for crimes committed with their products. This is like saying you can sue Ford or Chevy or Toyota or whoever because somebody was drunk in their car and killed somebody. So you could go sue them for providing the car that was used to commit the crime. That is, these people that made the guns have no control over what is done with them after they're sold. I'm sorry. U.S. District Court Judge Mary Dimke on March 8th dismissed a lawsuit against Washington State Attorney General Sideshow Bob, brought by the National Shooting Sports Foundation, which sought to prevent Senate Bill 5078 from taking effect. The bill known as the Firearm Industry Responsibility and Gun Violence Victims Access to Justice Act, that's a mouthful, imposes state-level legal liability on Washington's firearms industry, allowing lawsuits to be brought on behalf of people who are killed or injured with the industry's products. Tell me something. If this is our line of thinking, how we're going to do this, then how about we have laws that hold politicians responsible for death and mayhem that occurs because of bills that they pass? How about that? How about if we have a law that holds judges liable? They're allowing cops to be sued now for stuff that happens. You know, their immunity's been stripped. Now you've got this bill where the firearms manufacturers can be sued. Let's open it up to politicians and judges. Let's hold these judges liable and allow them to be sued when they keep letting these criminals back on the street 40, 50, 60, 70 times, hurting people, killing people, committing crimes, causing mayhem in the community. Let's hold them liable for that. The measure also opens firearms makers and sellers to legal liability if they fail to establish, implement, and enforce reasonable controls in the manufacture, sale, and distribution of firearms. Senate Bill 5078 was signed by Jay Inslee on April 25th, 2023. The NSSF filing its lawsuit on the same day. It's insane to me that it was just dismissed. Didn't even get to a hearing. Just dismissed. I don't know what to say. The judge stated in her order that the group failed to bring a live case or controversy before the court, while dismissing the case without prejudice, meaning that the issue can be tried again. It's just insane to me that they think, first of all, that laws like this are somehow going to protect people. These shootings are either crime-related, gang-related, or mental health-related overall. All of these mass shootings you can pretty much rack up to mental health issues, which the state completely ignores. You've got Looney Tunes running around the streets of every city in this state, in every state in this country, because we have no place to put them anymore and nobody treats them. So they're just out loose, running around, doing God knows whatever. And then they get their hands on a gun. Or you've got this mass shooting like in Kansas City that's gang-related that, of course, the media just quit talking about as soon as all that information came out. But somehow limiting law-abiding people's rights, which is always what they go after, because the law-abiding ones are the ones out there committing these crimes, right? Somehow that is going to make us safer. Somehow being able to sue the firearms manufacturer is going to make us safer. No, what they're trying to do is sue them out of business. So there's no one manufacturing firearms in Washington state anymore. No one willing to sell firearms to Washington state anymore. In fact, as it is with a lot of these laws that have been passed in this state, I don't know if you've noticed, but if you go online and try to order things like fanny packs for concealed carry or concealed carry undershirts, you can't get them. You cannot have them shipped to Washington state. Why? Because these companies feel like our laws are too convoluted or too difficult to figure out, and they don't want to deal with any repercussions that could come from it, so they just don't ship here. So you literally cannot order quality concealed carry undershirts or fanny packs or anything of that nature, like off of Amazon or other websites like that. So imagine how these gun manufacturers are going to feel about shipping their firearms to Washington State. They're not going to do it. They're not going to open themselves up to being sued by Sideshow Bob, who I'm sure can't wait to file his first lawsuit against a gun manufacturer. We've got to keep pushing back against this trash legislation and these trash politicians who are walking all over our rights. Shall not be infringed. Thanks for listening to Left Coast News. For more, visit leftcoastnews.net. Please subscribe, like, and share to your social media. We appreciate your support.